Okay. Well, good morning, everybody. Today is October 27th, 2022. Hard to believe that we're heading into the holiday months, but we are. And it's great to see you all here today. We have two very special guests today with us talking about insurance and mediation, and it promises to be fantastic. We'll get to the introductions in a few minutes, but first, as you all know, here at Will Work for Food, the New Possibilities Hour, there is no charge for these programs, and it was founded by Natalie Armstrong Motan in the spring, probably about May, I think it was, of 2020, and fantastic speakers now for 2.5 years. And all we've ever asked is that people make a donation to a food bank, either of the speaker's suggestion or of their own local choice. And then if they would tell us about it, we add it to a running total. And we know there are many people who haven't. If you haven't and want to catch up, that would be great. But anyway, where are we today, Jeff? This is always, I know you say it's your favorite part. How much do we know of for donations to food banks?
Thanks so much, Jean. It's just wonderful to be able to announce we've crossed another great threshold. Our generous audiences have now contributed $326,866.60 to food banks in honor of our great speakers. Thanks to our speakers, thanks to our audiences. Jean, back to you.
Thanks so much, Jeff. And thank you to all of you. It's truly an honor to be doing this, and it's such an honor to see and such a privilege to see the generosity of this group. And as I like to say, feed your mind while feeding the world. And we collectively, the global legal community certainly has and is doing that. So that's fantastic. All right, so for today, what we have here is we have two special speakers. One is my longtime friend, Dan Kohane, out of Buffalo, New York, and my other good friend from the American College of Coverage Counsel, Tyler Gerking, and he and I have given some seminars together, as I have done with Dan as well. And today they're going to be talking about insurance and mediation, and what mediators need to know, what practitioners need to know. So let me do a quick introduction. Tyler, well, first of all, this session is being sponsored by the ADR section of the American College of Coverage Counsel. And both Dan and Tyler are fellows of the college. Dan is a founding regent, or was a founding regent, and is a past president of the college. Tyler, he is on the policyholder side of insurance disputes. He helps policyholders maximize their insurance assets. He works with them and their insurance brokers to negotiate favorable terms. And then when lawsuits happen, he's there helping for insurance recovery. And he's so well known and respected. It's a pleasure to have him here today. He's with the firm of Farella Braun Martel in San Francisco. So if you need a policyholder lawyer, Tyler's your guy for that. In his spare time, he loves to ski, and he loves to run, let's see, it's some sort of marathons, ultra marathons is what it says on his website. So we're happy to have that information about you, Tyler. And then Dan is a nationally recognized insurance coverage counselor. He is everywhere, it seems like, giving presentations and seminars. He's a senior member at Hurwitz and Fine out of Buffalo, New York, where he is joining us from today. He has a special getaway on, or in Canada, a lake house that he loves, calls it the Land of Blue Martinis, where you might be able to find him during the summer months. He is a distinguished, he has served as an expert witness. He has served in all sorts of leadership positions. He's a past president of the Federation of Defense and Corporate Counsel and was awarded its Lifetime Achievement Award in 2022. past president of the FDCSF Foundation, served on the board of directors of DRI. In case you hadn't noticed, he's on the defense side, so he's representing the insurers in the same disputes where Tyler is representing policyholders. You might see his name in the paper being quoted at some point in time. And he's also professor of law at, let's see if I can
The Buffalo Law School.
Thank you, at the Buffalo Law School. And it's a pleasure to have you both here. Each of these gentlemen have designated food banks, and sorry, you will put the information, the links in the chat. And so gentlemen, I would say, why don't you, let's see. Food Bank of Western New York is Dan's, and Alameda County Community Food Bank is Tyler's. So gentlemen, I'll give you the floor. You can tell us a little bit about your food bank, and then the floor is yours, and we look forward to your presentation.
Thank you, Jane. I'll just give you a brief discussion of the Food Bank of Western New York helps the people in this community. Buffalo is a city with great poverty and great need. And the food bank does a wonderful job in helping those in need, and any contribution you can make on its behalf would be great. Tyler?
Yeah, Alameda County Food Bank is located in Oakland, California, where I live. And what's always impressed me about the food banks here, and it must be nationwide, is their buying power. Is you donate $1 to the food bank and it goes, it's worth $4 or $5 in terms of how much food they can buy. So that's always inspired me to donate to the food bank.
Great, thanks so much. So are you ready to get going then?
We're ready, Tyler.
Let's do it. I'll share my screen to put our PowerPoint up. How about that?
And we invite you to ask questions, put them in the chat box. We'll try to answer them as they come along. And if we have time at the end, we'll open it up for live questions, but we'll watch the chat box for questions if you have them.
All right. So can you see our PowerPoint?
Yeah, I can see it.
Okay, good. So let me move the slide here. I'll give a quick overview of what Dan and I are going to talk about. And this is presentation is aimed specifically to discuss how insurance kind of plays into settlement negotiations, and in particular in the mediation context. So we will be talking about insurance, and we'll assume some basic background knowledge on insurance so that we can talk more about the nuances of how the insurance sort of works in mediation. But we'll give a quick overview at the outset of liability insurance coverages that folks are likely to see in mediation. We'll talk about some basic insurance concepts quickly, and then we'll focus on the key players in mediation that touch on insurance. And there are actually quite a few of them. And, you always want to know your audience. And it's very important to know sort of who these people are, who they work for, and what their incentives might be to understand how they might be able to help the mediation process. And then we'll talk about some key insurance coverage issues that often drive settlement discussions. And the overall point here is that many different kinds of cases can involve liability insurance. And that liability insurance can make or break a settlement deal often. And there are often a lot of cross currents in terms of interests about how that liability insurance ought to come into play in settlement negotiations, and issues that can be hangups, or if you know what you're doing, can be resolved to help smooth or as I like to say, pave the path to resolution. So that's what Dan and I hope to accomplish today.
it's all about money at the end of the day, and it's really important to follow the money. This is what they don't teach you in law school. You know, all of us who went to law school, you learn about torts and contracts and criminal law and procedure, but they don't really teach you about money and how to get to it. And even young lawyers, more experienced lawyers who are involved in litigation often don't take the time to understand the importance of the role of insurance coverage in resolving litigation. So, you know, we'll just speak briefly about liability insurance. Again, we're assuming that basic knowledge, but obviously liability insurance is a coverage designed to protect an insured or a policyholder against claims by third persons for injury, personal injury, bodily injury, or property damage that arise out of an accident or an occurrence. That's a general rule for commercial general liability insurance, for auto insurance, for homeowners insurance. And of course, it provides the policyholder or the insured with a defense. And that means they provide it with a lawyer. Usually it's outside of policy limits. So in addition to the amount that's available to indemnify the insured, there is money available above and beyond the indemnity limits for defense costs. And that changes from time to time and policy to policy. For example, commercial general liability policies usually are like that, not always. Sometimes defense costs are within policy limits. Sometimes we call those burning limits policies, where the more you spend on defense, the less there's available for insurance, for indemnity dollars. So it's important when looking at a case where a defendant has an insurance policy to understand what kind of a policy she or he has that's being used to defend or indemnify it in the lawsuit. Obviously, there are special kinds of coverage. Directors and officers coverage provide protection for the directors and officers for claims against them for management of the company. Employment practices liability coverage would provide liability coverage for claims of discrimination or wrongful termination, those kind of things. Errors and omissions policies are generally your professional liability policies: medical malpractice, legal malpractice, travel agent malpractice, whatever technical name, errors and omissions. And then you have coverage for cyber liability, computer issues and technology issues, and for media liability for those involved in that business. So those are the kind of policies that you're probably going to be dealing with in many claims and many tort claims. And they're the bones, if you will, that are behind the claims that are present in the tort world.
One thing I would add here is that in each of these areas or types of coverages, you can have insurance policies that are stacked on top of each other in order to create a tower of insurance. So you can have a primary CGL policy or a primary D&O policy that may provide, $1 million of limit, or it may provide, $5 million limit. But then you can have excess policies on top of those that will provide additional limits that could be available to settle a case or pay a judgment. And that's particularly important and comes into play a lot in the mediation context, particularly when we start talking about who the players are, which
Sure.
Dan and I will do.
And for example, in construction litigation, you may have additional insured coverage where an owner or general contractor may be securing coverage under a subservient contractor's policy. An owner may get it from the general contractor, may get it from the subcontractor, et cetera. So all of those are important. And sometimes there are overlapping coverages, and it's really important to know which coverage applies. I'll give you one quick example. Imagine a claim involving a defective ambulance. Ambulance is driving along and dies out because the engine wasn't properly maintained, and the patient inside the ambulance it dies as a result of the ambulance not getting to the hospital. Is that an automobile claim? Is it a general liability claim for a lack of maintenance? Is it a professional liability claim? It's really important to know what policies are in play when dealing with cases like that.
All right. So shall we move on to the key players, Dan?
Yep, please do.
All Okay. Dan, why don't you start off with the key players on the insurance company side, and then I'll talk about the insurance side.
You bet. So on the insurance side, normally at a mediation, we have the defense attorney, the attorney who is representing the policyholder or the insured. And of course, that lawyer's role is to defend the interests and protect the interests of the policyholder or the insured. And generally speaking, that lawyer is not involved in the insurance coverage issues because his or her interest is to make sure that the insured is protected. So if there are insurance coverage issues, in addition to the defense attorney who's representing the policyholder or the insured, you would have somebody or some bodies who are there to resolve and counsel and advocate on behalf of the coverage issues. So that will be a claims professional of some kind, either a line adjuster or somebody who is higher up in the company. Generally, for insurance coverage purposes, it isn't a line adjuster who is involved in the coverage issue, and it generally isn't the adjuster or the professional who is assigned to the defense of the lawsuit. The companies will generally split the file. There'll be a different claims professional handling the coverage issues, and that person should be present or available for those issues, as should coverage counsel if coverage is going to be driving the outcome. So you're going to have the claim professional for the defense side, the claim professional for the coverage side, the defense attorney who's representing the policyholder, and the coverage attorney. And there may be other counsel. For example, if there's excess insurance, as Tyler mentioned earlier, you may have somebody representing the excess carrier who may have an interest in the outcome of the case as well. So you could have as many as 5 or 6 people involved on behalf of the insurance company and the defendant.
Quick question for Dan. Is the claims professional there with full settlement authority, or is there somebody else who might not be there lurking in the background?
And of course, that depends on the company. In some companies, the control of the dollar, the control of the wallet goes to the defense claim professional, the defense adjuster, if you will. In other companies, the person who controls the purse strings is the coverage claims person or his or her supervisor. So it's important to know that as a mediator, it's important to know that prior to the mediation, who is going to control the final decision-making when it comes to dollars being paid out. And as a mediator, when I mediate cases, I always try to determine who is the person ultimately responsible for the money, because that's the person you certainly want present at the mediation. It doesn't help you if the defense adjuster comes in and he or she has no control over the funds. Well, we have a coverage issue. We have somebody else involved.
Yeah, I think also what I always try to ferret out and identify is whether the insurance company representative who will be present at the mediation will have authority up to settle the case up to the policy limit, or whether they'll need to make a call to a supervisor or a committee back in the home office. And if so, then where is everyone located in terms of time zones? I'm on the West Coast, so particularly when we have a mediation out here, somebody's got to make a call to the East Coast, but the mediation here is ongoing at 8 or 9 p.m. That can be difficult to do.
Joanne's comments in the chat box are absolutely on point. It is useful. It's important. It's almost critical to explore insurance available to the parties in a pre-mediation discussion with counsel, especially defense counsel, because if they show up at a mediation without the people who can make the decision, the mediation is likely not to be particularly successful. Tyler, why don't you talk about the insured and policyholder side?
Yeah, absolutely. So on the policyholder side, you'll inevitably or invariably have someone from the policyholder itself or him or herself. You'll have in-house counsel, general counsel, or CEO, depending on the importance of the case and the mediation. In addition, you'll have defense counsel. Now, that defense counsel might be the panel defense counsel that Dan mentioned. If the insured and insurer are relatively aligned from a coverage standpoint. It may just be the company's or the insured's defense counsel may simply be the defense counsel who is appointed by the insurance company to represent them in the lawsuit. But if the insurance company and the insured are not so aligned on coverage, the insured may have their own independent counsel that the insured selected to defend them in the case. It's possible you could have both sets of attorneys there. Oftentimes you'll just have independent counsel if that's the situation that the insured and the insurer are in. But it's important to know if you're the mediator, who that defense counsel is, what their relationship is to the insured and or insurer, because an independent defense counsel may look at the case and the dynamic between the insured and the insurer differently than a panel defense counsel will. An independent defense counsel will often be paid, at least in part, by the insurance company, but their only client is the insured, as opposed to a panel defense counsel who really has two clients, the insured and the insurer. So there's a significant difference there, and it's really necessary to understand that difference and who you're dealing with. Also, the policyholder could have their coverage counsel in the room at the mediation. That coverage counsel is not defending the insured in the underlying suit, but rather is there to help deal with coverage issues and to help nudge the insurance company along to settle the case. And finally, these folks are usually not at the mediation, but they could be involved, and that would be the insurance broker, because the insurance broker may have placed the policy or policies that are being asked to settle the case, and that insurance broker may have either their underwriting personnel who have relationships with the insurance company, or they may have claims personnel who have been helping deal with the case or deal with the insurance claim, and the insured or their coverage counsel may be interfacing with them throughout.
And of course, you may also have, and we haven't talked about the underlying plaintiff. The underlying plaintiff may also have coverage counsel because he, she, or it has a real interest in making certain that there is coverage available so that the claim can be paid by someone. They often don't care who, but as long as it's someone, and that's usually an insurance company. It amazes me, it amazes me how infrequently plaintiffs bring coverage counsel to mediations.
Yeah, that's often the case. However, it may be the case that the plaintiff does not want the defendant to get insurance, and the plaintiff may be sort of intentionally pleading their case to prevent the insured from getting insurance, either sort of to punish the insured or for a tactical litigation strategy to prevent the insured from getting a defense coverage. So that's also important to keep in mind what the plaintiff's interest in the existing insurance may be. But that's true. Dan's right. I mean, oftentimes plaintiffs will have their own coverage counsel involved.
Let's move ahead a slide there and see what we have next.
All right.
You want to start out with this one? And
yeah, sure. I'll take this one. So from a mediator standpoint, I think it's important to keep the questions on this slide in mind as you're preparing for the mediation and going through it. Like I mentioned before, there are situations where there may be a pot of insurance money there. There's no dispute between the insured and the insurer, that is the insurer, is essentially agreeing to cover the case. And it's really just a question of how much should the insurer pay to resolve the case? What's the liability exposure? What's the reasonable settlement range for the case? What's their valuation of that? However, in many situations, you've got an insurance company that may be defending the insured, but has reserved its rights to deny coverage as to the insured's liability. And it's important to keep in mind, one, whether that may be the case, and two, what those issues may be. What may the insurance company be arguing is not covered? Because in a settlement context, you've got to keep in mind what the insurance policy actually covers in terms of the remedy or remedies that the plaintiff may recover in the underlying suit, because part of the case may be covered. So there may be claims that seek covered remedies, and there may be claims that seek uncovered remedies, or the insurance company may be simply saying this whole thing is not covered. We're defending you but we're not going to cover anything at the end of the case. So it's important to sort of understand how the insurance company may be looking at that, if that's possible. So there could be questions about whether the claim falls within the coverage in the first place. There may be exclusions that apply, or there may be conditions in the policy that the insurer is arguing that the policyholder has not complied with. And depending on what those are, that could really affect how the discussions go.
Yeah, let me speak to the additional insured issues, Tyler, because that's really one of my favorites, because additional insured issues lead to risk transfer questions, which are always part of a dispute. So let's say, for example, you have a construction accident case where somebody is injured at a construction site, and she sues the general contractor who has a claim against the subcontractor. They each have plenty of coverage. The case is worth $2 million. They each have primary and excess policies. So there's no issue about there being enough money to resolve the case, but there's going to be an issue about who's going to pay that money and how, either because of additional insured endorsements or because of contractual indemnity agreements, which may lead to risk transfer from the general contractor's carrier to the subcontractor's carrier. So if those issues exist, and they often do, additional insured issues are so common and they often interfere with a discussion. The plaintiff says, hey, we got all the money we need, but you can't get the people to pay it. You have to pay attention to those issues early on. You have to understand what those issues are, and again, who's going to make the decision relative to payment of claims.
Right, and that it's important to keep in mind, and often you could try to have a pre-mediation discussion or even a whole separate mediation before the mediation with the plaintiff to try to resolve those issues. But you've also got to keep in mind that there may be a sort of a cart before the horse problem, because parties often will not want to sort of agree how they might share in a settlement until they have a sense of what the overall settlement number may be.
But I think it's very useful when you have those issues coming up to have an early session with the defendants and their carriers, coverage counsel and their defense counsel, to try to get those issues resolved, or at least get them framed, because nothing is more frustrating to a plaintiff to come to a mediation and say, look, I have a case that's worth $3 million, and the defendants generally agree on the value, and the plaintiff sits on the side waiting all day as the defendants and their carriers are fighting about primacy of coverage and risk transfer issues, and that could end up frustrating a mediation, which we don't want to see happen.
Yeah, that kind of goes to the next question on the slide, Dan, which is, can the tort action be resolved without the coverage issues being resolved, where the defendants and their insurance companies essentially agree to fund a settlement, but reserve their rights to battle it out amongst themselves. How do you deal with that situation?
Yeah, the so-called pay and chase scenario. But you know, it's a very important. Sometimes you can get that resolved. You know, we don't want the settlement to slip through. We're willing to pay $3 million. We'll each chip in half of it, and then we'll fight out the coverage issues. That's great. The issue before that, Tyler, is also worth mentioning, and this is very, very important. Are there questions that could create precedent that none of the parties want decided? And I can't tell you how many times that's come up in mediations where there's a coverage issue involving some nuance of a policy provision that on Monday, carrier A may take the position that they want this interpretation, when on Thursday, in another case, they may want to take the position that another interpretation applies. And the worst thing for that carrier, in some ways, is to have that issue decided because it's going to impact them in other cases. That's one of the most important things to remember as a mediator when there's an issue of nuanced coverage law. There are many questions that carriers prefer not to have answered because they're afraid it may impact them in other cases in the future. And you, as a mediator, making that point to coverage counsel and to company representatives, I think, is very important. You sure you want to win this case? It's the fear of success. You're going to win this case on coverage. It's going to bite you in the next 20 cases you have on the other side.
All right. Shall we move on to the next slide, Dan?
Yeah. Mm-hmm.
All right.
Well, we talked a little about this already, and that's a question of who is making decisions. Somebody in the chat box said sometimes the insurance companies don't want to tell you who's making the decision. That could be, but you need a decision maker at the mediation. You can't be in a situation where and Tyler, you mentioned it earlier, where the person who's making the decision is not even in the same time zone or not even paying attention to the fact there's a mediation, and therefore is not present to make the tough decisions. You have to know that you have the decision maker there. Go ahead.
Now, if there is separate coverage litigation already ongoing, so often you'll have coverage issues sort of lurking in the background. Maybe they've been overtly aired between the insurance company and the insured, maybe not so overtly. But sometimes you'll have full-blown coverage litigation ongoing at the same time that you're trying to settle this underlying case between the plaintiff and the insured. Dan, in your experience, would you want the coverage issues to be mediated by the same mediator or have in that same mediation, or would you prefer to have them mediated by different mediators, or does it matter, or are there different solutions for different problems?
Well, I think the latter is, it's probably different solutions for different problems, but I think it's important not to overlook these cases, these issues. And if you have those of you who are listening to this presentation and do mediation work, as you appreciate the importance of understanding the relevancy and significance of mediating the coverage issues, that's part of your role. And if you don't feel comfortable doing it, or if you want some help doing it, you can engage. You could suggest engaging a separate coverage mediator to work out those issues. You can do it if you have the time and you have the energy and you have the ability, but it's really important to make sure that somebody works out those issues, because it isn't just the value of the case and the allocation of tort liability. It's the allocation of coverage between and among various parties who have different interests and may be at different levels and may have risk transfer issues. Those are critically important, and they have to be resolved either by you or by somebody else.
It's not uncommon for insureds and insurers to agree to fund a settlement with the plaintiff under a reservation of rights, or to at least sort of set the coverage issues to the side for the time being and then fight it out later. In California, where I'm located, there's a rule that permits an insurer to fund a settlement under reservation rights and then seek reimbursement from the insured later. Dan, how does an insurance company view that scenario where it really will be the insurance company funding and then chasing the insured for the money?
Look, I think
And does
every
that
insurance,
impact how the
well,
how the mediator may look at it?
I think that most insurance companies like to close the file. I mean, closing a file is an important thing. And rather than having another 3 years of litigation over coverage, the preference would be to find a way to close the file close the coverage issues at the same time as you close the tort issues. That's the preference. But sometimes you have a case where you have a very sensitive time-sensitive case to settle a matter, and you don't want to lose that opportunity. Maybe the case is ready for trial, and you're afraid of a runaway verdict in the particular jurisdiction, and you can get the case at a number all parties think makes sense. In that situation, a pay and chase approach makes sense. We don't have, I'm in New York, we don't have a rule that automatically allows an insurer to go back against its policyholder to recover back fees or expenses paid. But if you want to cut that deal in New York and some other jurisdictions, you should have a side agreement that allows you to do that. So it depends on the case.
Because from my perspective, from the policyholder's perspective, it's in this sort of area where a mediator can have a lot of impact in sort of bringing a case to resolution where the insurance company may not be cooperating, and that is where the plaintiff may be demanding certain amounts that are above available insurance limits. And in that case, the insurance companies feel very little pressure often to actually settle the case because they don't face any real exposure themselves if the case doesn't settle. If I can, as a policyholder side representative, can get the plaintiff down to a demand within the policy limits, then the insurance companies will face much more pressure to settle the case because of the rule that if the insurance company receives a demand within available policy limits and refuses to accept that demand and pay it, then if the case proceeds and results in a judgment that's excess of the limits, the insurance companies are liable for the entire judgment, irrespective of what their limits were. So,
well, that's a state by state thing, Tyler, as you know. And for example, just last week in New York, there was a decision where an excess carrier sued a primary carrier for not settling within the limits, and they could have settled within the limits. There was an excess verdict, and in New York, which is a state that's very, very good to insurance companies in bad faith, they found no bad faith, even though the case could have been settled within the limits. They thought they made a reasonable attempt to settle the case. So it's gonna, that's the importance of your comment, Tyler, and my response is each state is different, and we have to understand the rules that apply to bad faith as well as coverage in the jurisdiction where the dispute is being resolved.
No, that's absolutely true. Absolutely true. But I'd say generally speaking, if most states will say that if the insurance company or insurance companies receive a settlement demand within the total limits available and they don't accept it, then if the case proceeds to judgment and the judgment is in excess of the limits, then they're at significant risk of having to pay the entire judgment.
It's certainly at a greater risk. I agree with that.
Yeah, I mean, and basically the principle behind that is that once the insurance companies have a settlement demand from the plaintiff that's within their limits, they're gambling with their money, not the insured's livelihood or the insured's business in terms of an excess judgment. But what's often important, very sort of critical, and this is particularly the case in California, is to understand what a demand is, what kind of demand actually sort of imposes that pressure on the insurance companies. And it's got to be a demand that will resolve all of the insured's liability, and it's also got to be an actual demand. It can't be sort of a hint that the plaintiff might go there, and that the insurance companies ought to sort of make offers in order to get the plaintiff there. So as a mediator, it's important to understand what the limits are, what the available limits are, and how to kind of maneuver the plaintiff into that zone where the insurance companies are actually going to feel some more pressure to settle the case.
And why don't we move ahead with the slides?
Okay.
So what are the considerations we face? I'll talk about the insurer side, and Tyler will speak about the policyholder side. Obviously, prior to entering mediation, the insurer needs to know certain information to resolve the case. In certain jurisdictions, especially around here, we have early mediations in federal court, mandatory mediations in federal court that are conducted prior to the discovery being undertaken. And we have a mandatory mediation program that requires it, an ADR program. So if an insurer is going into an early mediation, there may be certain information it needs that are critical that have to be obtained prior to the mediation. That may impact both liability and damages. There has to be a concern always about the cost of defending a case. Very important, particularly if it's a burning limits policy and you spend $100,000 in defense costs and it reduces the available limits. Important. You have to understand the carrier has to be prepared to discuss the coverage issues, recognize the bad faith exposure. As we discussed in the previous slide, it's going to depend on the jurisdiction, but if there's a settlement demand within the limits, I certainly agree that there's a greater risk of extra contractual liability being imposed on the insurance company. You need to know about internal reporting, who makes the decisions internally. There may even be questions of, has the reinsurer been notified of this particular claim before the case is resolved? The issue of finality, or on the other hand, pay and chase, it may be an issue for the company. And there may be an important question about the time needed to make settlement payments after the case is resolved. It's important to make certain that if you're in a mediation on a tort case and there are outstanding coverage issues that haven't yet been resolved, that the parties specifically reserve the right to resolve those issues either in a separate declaratory judgment action or a separate mediation, because otherwise there may be a claim that you have waived those issues or you're stopped from arguing those issues because the case is over. So one has to be careful when crafting that mediation agreement to make certain that if they're going to be a pay and chase situation or a lawsuit, that you specifically reserve the right to handle those issues at a separate time. Another recent case out of New York, that didn't happen, and the carrier that thought he had a coverage issue, to resolve separately, lost its right to resolve the coverage issue because it wasn't preserved in the settlement agreement.
On the flip side of the same coin, the insured's concerns are often that the insurance company will fund the full amount of a settlement, and that the insured won't have to contribute to any settlement. Now, that completely depends on the case and what's alleged. Like I said, there may be cases where, or there are cases where certain claims are covered and others arguably are not, or may clearly not be covered. But that kind of goes to the first couple bullet points under the insurer's decision making, which are actually very important to the insured leading up to the mediation, and also actually ought to be important to the mediator, which is that the policyholder needs to, well in advance of the mediation, ensure that its defense counsel has reported to the insurance company what the case is about, what the defense counsel's views are on liability and damages, and future defense costs, because it's that reporting that the insurance company bases its decision making on. So if the defense counsel is not thinking about coverage issues or not aware of coverage issues, they may say, "Oh, this whole case is, big liability exposure, but it's all on a claim that happens to be uncovered." So a lot of what we do in preparing for mediations is helping the defense counsel sort of identify what the liability exposure is really on, how much it is relative among the various claims and maybe various parties, to help prepare the insurance company as sort of thoroughly as possible for when that settlement discussion is actually going to happen. Also, we've talked about before, insureds are going to be concerned about indemnity claims between co-defendants. An insured often will not want to resolve a case or resolve a coverage dispute with its insurer by releasing its insurer until potential indemnity claims against it have also been resolved. The insured also may not be able to resolve indemnity claims that it has against other parties without getting the insurer's consent, because it's the insurer who's paying the claim that ultimately will have the rights, the subrogation rights, to go after a third party. And the insured may essentially be hamstrung in resolving those claims unless the insurance company is also on board. Finally, we're also, we've talked about possible resolution of coverage issues and whether you resolve those as part of the mediation or separately. But another important point to keep in mind is outstanding defense cost issues. So often the insured may be coming into a mediation with some of its defense costs paid, but maybe a significant chunk of its defense costs remaining unpaid by the insurance company because either it's just been slow in paying, or the insured has been slow in submitting the defense costs, or there are disputes about what defense costs are covered and not covered. And if the insurance company is maybe agreeing to pay part or all of a settlement, but those defense cost issues are still in dispute, it may not be possible to actually reach a final resolution with the insurance company at the mediation. So that's another thing just to keep in mind. What happens if the insurance coverage issues just go unsaid or are not resolved at the mediation? Sort of what's the impact of that on the insured defendant?
Yeah, and that's why it's so important to make certain when you're trying to wrap up a mediation as a mediator that you make it, you make certain that the insurance coverage issues are either resolved or to be resolved, whether it be between carriers and risk transfer or other insurance issues, or between the carrier and the policyholder. Because if those issues are going to be continued, there shouldn't be any question about that. And there should be some reflection of that in the paperwork between the parties when the case is being resolved.
Okay, so if the take an example where the money, the only money that's really available to settle a case is the insurance policy, but the insurance company is not willing to pay it to settle the case. That leaves the insured in a bind. It literally can't settle the case. It would be forced to go to trial against the plaintiff, but it also puts the plaintiff in a bind because the plaintiff is going to spend time and money taking a case to trial where where it's not really, one, necessary, but two, where recovery is going or collection is going to be uncertain. So it is possible for an insured and the plaintiff to enter into an arrangement that would essentially allow the plaintiff to pursue the insurance company directly. And we won't get into all the nuances of this, but it is an option that mediators ought to be aware of, and one that might help actually settle the case in a way that would protect the insured and give the plaintiff the rights to pursue the insurance coverage. But that sort of deal can be complicated. It often involves an assignment of the insured's rights against the plaintiff in exchange for a covenant not to execute against the insured on any judgment, and can also involve sort of questions about whether the plaintiff and the insured can or should be agreeing to an amount, or rather they should be agreeing to go to an uncontested trial and have the amount that the amount of the judgment to be determined basically by a judge after the insured has appeared but not put up any defense in the trial.
Yeah, I think, go ahead.
Oh, go ahead.
I was just going to comment that it's, I think, critically important for a mediator to understand what options may be available, because in discussing these claims and caucus with various parties. I'm not suggesting the mediator recommend any particular course of action, but at least the mediator should be familiar with the protocols that are available, so mediator can speak to the parties about what could happen if this case doesn't settle.
I'm just looking at a question we got. We got a couple questions in the chat. One is, given mediation confidentiality, can a policyholder prove bad faith if the insurance company refuses to settle within policy limits during mediation, and there is later a judgment in excess of policy limits? So this is a really good question, and has a sort of very practical impact on how we do things in a mediation or outside of it. Oftentimes you'll be in a mediation. Plaintiff will demand an amount within the policy limit. Insurance company won't agree to pay it, but this is all taking place within the context of a mediation where often there is ironclad confidentiality, and you could never introduce any of that. The policyholder would never be able to introduce any of that into evidence in a later bad faith trial. So if that is really what's happening and that's an acute problem, oftentimes we will break from the mediation, send a communication to the insurer outside of the mediation and make it clear that this has nothing to do with the mediation. So this is not mediation privileged. And then often the mediator will communicate with the plaintiff, or maybe we will communicate with the plaintiff to say, hey, we need a demand from you. Maybe it's the same demand you've already given to us, but we need it outside of the mediation. So the plaintiff will send a letter that's not subject to the mediation privilege outside of the mediation, and then we'll present that to the insurance company outside of the mediation and make a demand that the insurance company accept it. But that and that's sort of a critical piece, because if you were doing that within the mediation context and under the mediation privilege, the policyholder won't have the evidence that they need if the insurance company refuses to accept the settlement demand, and two, trying to do it in the mediation context really won't put the pressure on the insurance company that you want, because the insurance company will know that the policy won't have that evidence.
Yeah.
But
The
that's
other
a really
alternative,
practical question.
the other alternative is to wait till the say in the mediation, look, I understand this is all confidential, but this case doesn't settle. I'm going to send you a demand tomorrow morning with a demand within the policy limit. So I can't do it in mediation. I can do it. I could do it tomorrow when the mediation is over. So that would put the same pressure on the carrier, I think. So
yeah, absolutely. I mean, and the insurance companies know how this works. So just sort of telegraphing to them what likely is to happen if they don't accept the settlement demand, and that's often going to be sufficient.
Yeah, there's another question in the box. How to explain refusal by insurance counsel to settle even when the gap between the parties is trivial relative to the downside risk. As a mediator, I often find the posture of insurance counsel baffling. Well, sometimes I'm not insurance counsel, so I appreciate the problem and the frustration you feel sometimes. But, you know, again, sometimes the issue for the insurance carrier is more than a particular case where the matter is being resolved. They may have they may be trying to make a point that it's important, not only in this case, but other cases. You know, carriers are in the business of litigating. They know the cost of, defense. They know the cost it takes to resolve insurance coverage issues. And obviously practicality sometimes tells an insurance company to swallow their pride and settle a case. But it's a challenge when the insurance company is trying to make a point. This issue comes up all the time. They decide we want to draw a line in the sand on this issue, and they don't want to make the payment. You know, one of the arguments we always tell a carrier is, look, you know, you may lose this issue if you litigate it, and it's going to create bad precedent for you. That's usually the most effective means to convince an insurance company not to draw a line in the sand. As one of my partners used to say, if you draw a line in the sand, make sure you don't want to step over it. And there's some truth to that.
I was just told in a mediation this week that if we were to draw a line, we should draw it in the sand because you can erase it.
There you go.
Okay, so I don't know if we have any other questions, but we're nearing the end of the time. We can move on to get into more substantive coverage questions, but I'm not sure we want to do that given we have just a
probably
couple
not.
minutes
I
to
forgot
go.
what the next slide is that we put together. That our formulaic slide, is that what we're up to? If
Yeah,
we won't go there then. Yeah, so we'll take questions as we go forward. We're happy to answer any questions. You can put them in the box or unmute yourself and ask the question, but we want to see if we can answer the questions you have.
Well, until there are more questions, I would just want to say to everybody, you have just heard two masters of insurance speaking, and this is the quality of the lawyers that have been invited into admission in the College of the American College of Coverage Counsel. So if you need a policyholder lawyer, Tyler's right there for you. If you need an insurer lawyer, Dan's there. And I do want to mention, I got so caught up in that ultra marathon that Tyler was running. I neglected to mention his professional distinctions, which deserve mention, of being listed as the top lawyer in Chambers, which is fantastic, and best lawyers in America for insurance law. And that his practice also includes privacy and cybersecurity, data analytics, and technology. So both of these gentlemen are examples of fantastic insurance lawyers, and this information was great. I can't thank you enough. Does anybody have any other questions? Otherwise, we're getting to just about the top of the hour.
And you can reach out to either of us afterwards if you have any questions, you want to follow up some of the discussion. You know, we're available, obviously. Just send us an email or contact us. Happy to do it.
Well, I can't thank you. Yeah, that's wonderful. Thank you both so much. And I just would ask everybody to please remember the Food Bank of Western New York and the Alameda County Community Food Bank. Again, the links are in your chat right now before we sign off. And thank you so much for being here today. Thank you again to our speakers, and we'll look forward to seeing you next week. Thanks so much. Bye-bye.
Thank you.
Bye-bye.
Thank you.